Good morning, everyone. Thank you for joining us for today's online talk, which will be starting. For those who are here early, thank you for waiting patiently. While you're waiting, we would like to share you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk. My name is Elisa Nusraya. I'm a pupil in Chambers with Ma Weng Kwai and Associates, and today I'll be the moderator for this talk. Before we start today's talk, let me introduce the firm and what we do. Ma Weng Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Weng Kwai. Our able team today comprises of 33 lawyers and a support team of 30, where Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment, industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, where some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective. This objective is to share knowledge, raise awareness, and encourage networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation where the details will be given at the end of this talk. For today's talk, we will have two speakers. Allow me to introduce our first speaker, Mr. Navin Joshua Solomon. He is a senior associate of this firm. He was previously admitted to the Malaysian bar in April 2017. Currently, he is the senior associate in our dispute resolution, employment law, and industrial relations and individuals and families department. His areas of practice includes the law on employment and industrial relation, advisory, and litigation matters, as well as general litigation, which includes contractual disputes and debt recovery. Next, our second speaker is Ms. Caroline Ng. She is an associate in our dispute resolution department. She graduated with Bachelor of Laws with first class honours from the University of the West of England, Bristol. She was then admitted to the High Court of Malaya in March 2022. Her areas of practice are general litigation, intellectual property, employment disputes, and strata management. So let's move on to the first two talk points for today, which are Malaysian law on unfair dismissal of employees and differences between direct and indirect termination, which will be covered by Miss Caroline, and the last two talk points, namely the guidelines for employers and employees in the termination process, as well as remedies, common misconceptions, and case laws on the termination practices will then be covered by our second speaker, Mr. Navin. We will then lastly conclude the talk with a Q&A session. Hence, if you have any questions, please don't forget to post it up in the chat and we will address them at the end. So now I will pass the floor to Miss Caroline to begin our talk for today.
Good afternoon, everybody. Thank you so much, Alyssa, for that introduction. As mentioned previously by Elle, I will be taking on the first two talk points for today, starting with Malaysian law on unfair dismissal of employees. Here we will cover what is usually considered by the industrial court when deciding whether there has been an unfair dismissal. So first of all, we have to look into what is unfair dismissal. The main consideration by the industrial court is whether termination has been carried out without just cause and excuse. This term just cause and excuse originated and can be found in Section 20 of the Industrial Relations Act, which specifies where a workman, which is an employee, irrespective of whether he is a member of a trade union or workman or otherwise, considers that he has been dismissed without just cause or excuse, may make representations in writing to the Director General to be reinstated. So in this case, it's very clear from the top to bottom view of termination, when you bring a complaint to the industrial court, the first thing, the main consideration by the industrial court is whether the dismissal was done with just cause and excuse by the company. We can see it in application here, without just cause and excuse was defined and used by the federal court in the case of Gun Ki Poi against J&P Coates Berhad, where the court said that if the employer chooses to give a reason for the action taken by him, the duty of the industrial court will be to inquire whether that excuse or reason has or has not been made up. For example, here, if the employer is going to terminate an employee and say that it's because of poor performance or gross misconduct or sexual harassment, the job of the industrial court here, where there has already been a dismissal, is to decide whether it was done justly and with excuse. Did the company make out this excuse against the employee before deciding to terminate them? As you can see from the screen, the case here is in 1981. However, the term without just cause and excuse is still used by courts today. Here I have a case, Lai Suk Fan against Mbank, Sendirian Berhad, and this was in 2023. And the court still says, in the portion that has been highlighted in the middle of the screen, the function of the industrial court, after all, is to determine whether the termination was with or without just cause and excuse. From the front parts of this quotation, we can see that the court has also said the right to terminate is conditional. In specific to this case of Lai Suk Fan, it was conditional upon unsatisfactory service or work performance. The employer must reasonably be satisfied as to unsuitability of permanent employment and cannot terminate arbitrarily or capriciously. So here we can see that in cases of dismissal, where there has been a complaint made by an employee who has been terminated, the court is going to look into the reasons for termination. Is for the industrial court this portion is for the industrial court to decide. Yes, you as a company may have your reasons for terminating. You may have all of them listed, but at the end of the day, as we usually tell companies and employees like the same, it comes down to the evidence that is available before the court for the court to make such a decision. Now, examples of just cause and excuse. Of course, this is a very general overview, and it would take, of course, a little bit more of an intrinsic view into each individual circumstance for you to be able to decide just cause and excuse in these situations. But an overall example of just cause and excuse can be poor performance, misconduct, insubordination, not complying or not obeying the instructions or directions of the company, sexual harassment, and retrenchment. So even in a case of retrenchment, the company will need to show that there is an actual need for retrenchment. There is an issue financially with the company that they cannot keep on as many employees as they have. The second thing that the court will also look into when deciding a case of unfair dismissal is also proportionality. So is it proportional for the company to have terminated the contract of an employee because of the reasons that were given? So yes, an employee could have poor performance or have conducted certain forms of misconduct, but was it necessary and was it proportional for the company to have terminated them on that basis? So in the case that I have here, Norizam Bakar against Panzana Enterprise Sdn Berhad, the industrial court could substitute its own view in place of the employer's view as to what should be the appropriate penalty for an employee's misconduct. So the industrial court will take on that position of the company and make a decision there as to, if I were the company, would I have terminated this employee based on the reasons that have been given? So in these situations, we also have to look into direct and indirect dismissal to distinguish what is needed and how it will go about in the considerations of the industrial court. So direct dismissal is the most straightforward form of dismissal. This is when the company themselves send you a letter, the employee that they have been terminated. So examples of when this happens, like I mentioned previously, poor performance or misconduct in the case of retrenchment or in the case of summary dismissal. The process of handling a direct dismissal, though, is very important. It is not enough for a company to just rely, especially in the case of permanent employees, it's not enough for a company to just rely on the terms of the contract, that the employment agreement that they have with the employee. So for example, if your contract says either party may terminate this with 2 months notice or in lieu of that compensation, that is the standard line, the company, if they want to terminate you, will still need to provide a reason. So the process here is, first of all, the company will need to, in a situation of poor performance, misconduct, or summary dismissal, the company will need to ensure that they conduct due inquiry. So they look into the evidence that they have. For example, if it's poor performance, look into the performance of the employee from when they first started to perhaps 2 years or 3 years down the road. And what are the issues that have been raised by perhaps fellow colleagues of this employee that there is this issue in the first place. Second thing is to inform the employee, tell that, have that communication with the employee to say, hey, we noticed that this is happening, and tell them ways that they can improve or give them the opportunity to improve, basically. And you also have to give actual opportunities for improvement. So give them time, or for example, you can put them on a performance improvement plan. Now, in situations where it is perhaps not improving, or perhaps this is going on for quite some time, then you can choose to issue a show cause letter to the employee. This is listing out all the issues with their performance and basically asking them for an explanation on it. And then you can, if you have given them a specific time and once everything has been completed, they still do not improve, you can go ahead and issue a termination letter. The most important thing for employers is to show that the termination is procedurally fair. Enough notice, enough time to improve. Those are things that are usually looked at by the court. The other main thing to ensure is that throughout these steps, these procedural steps, it is very important to ensure that there is a paper trail of some sorts, whether that is by email, by WhatsApp correspondence, by letters. Everything has to be kept record of to ensure that later on, if after this termination process, the employee still chooses to bring this as a complaint and it goes up to the industrial court, everything is already there for the court's consideration. Indirect dismissal is where the dismissal does not technically originate from the company. The two examples here are constructive dismissal and forced resignation. So I'll be first dealing with constructive dismissal. Constructive dismissal is where the employee leaves or walks out of their employment as a result of the employer's actions. In these kind of situations, the burden is on the employee to prove that the company has acted in a way that has breached the contract, where I have no choice as an employee but to leave my employment. The alleged employer's actions are often one which would be considered to be repudiatory, and when the employee fails to address their actions, the employee is left with no other choice. So examples of situations where companies have acted in a manner that shows they no longer intend to be bound by the employment contract is, for example, non-payment of wages. So you don't pay your employee salary, that is ground for constructive dismissal or demotion. Unilateral reduction in wages or removal or substantial reduction of job functions. So all these things we can say and argue that this goes against the fundamental express terms of your contract, your employment agreement. There is also now a consideration by the court where if the employer has gone against the implied term of mutual trust and confidence the employee can also then consider themselves to be constructively dismissed. But of course, this will also require some nuance, and it's a bit harder to prove, because this is where it's very important to make sure that there is evidence and paper trails of everything that is happening. An example of going against mutual trust and confidence in a constructive dismissal case is frustrating an employee to the point where they choose to leave. So making their lives so hard on day-to-day, not technically going against any of the terms of the employment agreement, but just making it intolerable so as to force them to resign. So the elements in order to prove a case of constructive dismissal includes, first of all, a breach of contract, as mentioned previously, that can be express or implied terms of the contract. The second element is that it must be sufficiently important to justify, so the breach must be sufficiently important. From the time the employee notices or has indication of this breach of contract by the company, they have to inform the company. They have to give the company time to rectify this breach. So if, for example, if that's non-payment of wages, if you as an employee write into your company and say, hey, you have not paid my wages from this time to this time or for one specific month, I'm writing to put you on notice. If you don't pay me within a week, 2 weeks, I will consider myself as constructively dismissed. So you must inform the company, it must be in writing. The fourth element is that you must leave. In constructive dismissal cases, the court will consider that if you stay on after you have noticed this breach of contract by the company, it is you accepting their behavior. For the second example of an indirect dismissal, we're talking about forced resignation. Forced resignation is where your resignation is non-voluntary, you are under compulsion to resign, and it is a form of unfair dismissal at the end of the day. Here we have a quote, says the precise formulation by the employer is immaterial, whether it be by invitation, request, or dictation, so long as the substance of it is that the employer places his employee in a position which the employee really has no option but to tender his notice. In this situation, the reality is that the employee is dismissed. The difference here between constructive dismissal and forced resignation is, it mainly comes down to this. For constructive dismissal, your company, the employer, has gone against a fundamental term in the employment agreement. But for forced resignation, it is the company inviting you, telling you, asking you to resign, saying that if you don't resign, we are going to terminate. That's an example, saying things like, if you don't resign, we're going to terminate you anyway, so you might as well resign. The standard for proving a forced resignation, here you must show this burden will also be on the employee again, to show that it is not merely a suggestion to resign, it is a forced resignation. If it can be shown that the employee had the chance to take independent advice before offering his own resignation, then it's not forced resignation. The kind of pressure that we are talking about here is, for example, there are cases where if the employer or the manager or whoever it is calls you into the office, sits down and either forces them to sign a resignation letter, or there's a case where the employer forced the employee to type up the resignation letter in that room itself. That showed that the employee really had no other option. They could not have taken independent advice. They could not have left that situation. So now that we have gone through the direct and indirect dismissals, I will pass it over to Naveen to speak about the guidelines for employers and employees when they face the termination process and how to go about things in that situation. Thank you.
Thank you, Caroline, for that informative session. Also, thank you, Lisa, for that wonderful introduction. A very good afternoon to everyone for joining us for this online talk. I believe Caroline has already explained with regards to the types of termination and the standards required. I will now take over the session by explaining further on the guidelines for employers and employees with regards to the termination process. Bear in mind that these guidelines do not actually preclude or exempt the employer from an unfair dismissal claim. However, it goes a long way in enabling or assisting the company or the employee, in fact, in presenting their case. I will begin with the guidelines for employers. It is important for employers to take note of complaints that are made against them, especially to carry out the necessary investigations. I believe that this is something that should already be at the back of the mind of an employer, because when a complaint is raised, definitely something is bothering the employee, and it is up to the employer to find out whether there are merits to this, not just to brush it off. And when these complaints and investigations are made, the burden is on the employer to ensure that the investigations are carried out and due inquiry is done. And at the same time, ensuring that there is a proper bookkeeping of the steps. When we talk about proper bookkeeping, essentially it means proper documentation. We need everything with regards to information that is communicated to the employee and also whatever that is said back to the employer. All this needs to be kept chronologically to ensure that when the time comes, in the event of an unfair dismissal claim, these documents are all produced, exhibited, and shown before the industrial court. It is also vital that the concerns raised by these employees and these complaints also that have been raised are also addressed in any way, whether it is by way of a meeting or by way of an email, to at least show that the employer has taken the necessary and reasonable precautions and steps in addressing these complaints. Next, the employers would also need to ensure that proper records are kept, again, back to the documentation. But this is essentially in regards to the employees' performance and also the feedback from the employer in relation to that performance. Most companies tend to ensure that these are all properly recorded. However, there are a few where they neglect, or in a way they tend to think that certain documents are not necessary. However, when it comes to performance, every document is vital. We need to know why was the employee's performance bad, why was it not done, and how could the employee have performed better. And when it comes to the better performance, how it can be done, this is where the feedback from the employer matters a lot. The employer also needs to make sure that when these terminations are carried out, it is done in a non-victimizing manner. When I say non-victimizing, it means instead of rushing to remove someone just because the management does not like a particular employee. This, as you all know, fellow HR practitioners, you may have come across at times where sometimes HR personnel are informed that just because the higher-ups are not very fond of this particular employee, when they keep questioning the management, the instruction is to remove them at all costs. So what I would like to point out is to ensure that the HR personnel inform the superiors that this is definitely not the way to go about it. And lastly, one of the guidelines, of course, there are many other guidelines, but also one of the more important guidelines for employers is to afford the opportunity to the employee to provide an explanation with regards to their behavior or performance. This is important because many of the industrial court cases, they lack the response from the employee, as in the claimant. Often companies tend to carry out unilateral actions which are very much non-favorable to the company. Before I end the guidelines for the employers, one of the things that I hope that the message goes across today is that HR personnel, say the HR department, is the most important department when it comes to facilitating industrial relationship between the employer and the employee. The HR department works as a bridge where the complaint is raised by the employee, passes to the HR department, it goes to the employer. In turn, the employer then passes back the solution through the HR after negotiating with them and passes it to the claimant, the employee. This bridge needs to be solid. As such, the HR department needs to be independent. Of course, it is slightly difficult, but it is something that can be achieved if proper communication is done between both the employer and the HR, and also the HR and the employee. Next, we will go into the guidelines for employees, whereby employees need to also again ensure that there is proper documentation of all letters and correspondences between employer and employees. In the event that an employee wants to file a complaint against an employer, they need to ensure that everything is done in compliance with the relevant legislations. Here, when we talk about the time limit, it's 60 days from the date of dismissal. So when you lose your job at your last day of the company, you need to make sure that you file the complaint within 60 days of that. This time limit is non-negotiable. It is mandatory by way of the Industrial Relations Act. And appeals that have been done with regards to this time limit has not been entertained and have been unsuccessful. Next, employees also need to make sure that complaints and grievances are recorded in writing. Even emails or WhatsApp messages, they make the most differences in industrial court proceedings, because as claimants, you should avoid reliance on just verbal communications, because it's not going to do you any favor, and only whatever that is in writing will help you advance your case. Then we move on for meetings between employer and employees. As employees, you should make sure that in the event that you want to record the meeting, these recordings need to be consented by representatives of the employer. In the event that there is no consent, the more favorable method of ensuring that all of these details are captured are to record minutes. And this burden of recording the minutes would be on the employer. So this employer would need to carry out the meeting while recording the minutes and providing a copy to the employee in order for the employee to ensure that their version of it is also right. So these are the guidelines for employers and employees. Of course, again, I would like to state that this does not preclude an action being taken against the company and by the employee, but it helps both parties to at least try and ensure that their cases are properly advanced in the industrial court. I will then move on to the part of this talk which talks about remedies, common misconceptions, and case laws in relation to termination practices. I will start with the remedies. As when a case has been decided and the award is delivered by the industrial court, you will receive two headings in the award, which is compensation and back wages. Compensation is 1 month's salary for each completed year of service. When I say each completed year of service, take an employee which has served the company for 12 and a half years, which is 12 years and 6 months. If they receive the award for compensation, they are only getting the compensation of 12 months. Since the 6 months is not a complete year, so even though you have served the company for 12 years and 6 months, you only get an award for compensation of 12 months. Then there is the back wages part. And in this part, you will receive a monthly salary from the date of dismissal till the date of the award. And in this, however, the industrial court, via its practice guidelines, have capped the maximum to amount of 24 months. So even if the date of termination and the award, in between there's a time of 3 years, it is still capped at 24 months. Throughout the years, the industrial court have also practiced the practice of deductions, in which they take into account post-dismissal earnings and also any termination benefits received by the employee, whether by the termination benefit regulations or by any separation package. So in that, the court can scale down the award maybe by 20 to 30%, but there have been instances where even 50% has been done. I then move on to the common misconceptions on termination. There are many common misconceptions, but one of the most regular that we have been seeing throughout the years has been that these 5, which is employers are under the assumption that they do not have to provide a reason for terminating an employee. Employees cannot bring an action if they have signed an agreement which precludes them from doing so. Employers have to hold a domestic inquiry to terminate an employee. And then there is the 3 warning letters rule. And lastly, as long as you terminate according to the notice period, the employee cannot challenge the termination. All these concepts have been disproved by case laws. We will go into that after this. For the first case law that we're looking at, termination without any reason. As any termination needs to occur with cause. In this recent case of Omar bin Othman, it's been decided that even though the claimant was terminated based on Article 3, which provides for a contractual right to terminate, it is still unlawful because there was no reason for the termination. It was not based on, like you see on the screen, not based on poor performance, misconduct, redundancy, or anything else, any direct or indirect dismissal. So it shows that the company merely terminated him because they could. It was without any reason. And then we go to the more interesting case where most companies or maybe employees also don't know the issue of estoppel. So there are claimants that maybe sign an agreement, maybe a separation agreement or any other agreement in which the company gives them a certain amount of money and they part their ways. And at the end of that agreement, it is stated that the claimant is precluded from bringing any action against the company in relation to that employment. But what needs to be known is that by virtue of the Supreme Court case, Kumpulan Perangsang Selangor, the doctrine of estoppel does not apply in industrial adjudication. So technical rules have no place in industrial adjudication, which means that an employee can still bring an action against an employer even after they have received a certain sum. This is due to the special relationship that an employee and an employer has. There is a degree of control and also a master-servant relationship. So due to this unique relationship, it is clear that the courts have taken note of this and clearly stated that estoppel has no place in the industrial court. However, just last year, there was a case to distinguish this principle laid down by the previous case. In the Court of Appeal case of Matrix Global Education, in this case, the claimant negotiated a settlement, entered into various discussions, and then later on, when it was agreed, he left by saying that he was constructively dismissed. He won in the industrial court. He also won when the company appealed to the High Court. However, when the company appealed to the Court of Appeal, the court clearly stated that the claimant cannot have the best of both worlds, which means he cannot negotiate and accept the terms and then later on say that he was constructively dismissed. So I think what this case means to say is that if you were to have just taken the separation agreement at the outset without discussing or negotiating, you could have a chance to claim for constructive, or maybe not constructive dismissal, but maybe termination, unlawful termination. However, this claimant instead chose to go by way of constructive dismissal. So that is where the court clearly said that the claimant cannot approbate and reprobate. We then move on to the case of Bimac Powerhouse, which is in relation to the 3 warning letters rule that I was talking about earlier. There are companies that believe that when you give someone 3 warnings, that would suffice and the company can proceed to terminate the employee. However, it must be clearly pointed out that the Employment Act provides for due inquiry under Section 14. And how, even though this is not properly explained, and how this due inquiry is to be carried out also was not explained, it is clear that due inquiry means at least affording a chance or an opportunity for the claimant to at least explain themselves. So here, a notice to show cause would be a very crucial step. Warning letters are fine, but if you want to go on to terminate someone, you have to ensure that there is a notice to show cause. Most important part of this, allowing the employee to at least explain his part of it. Courts have also gone on to suggest or also provide opinions as to what other kind of punishment that you can give instead of only termination. Of course, the topic today is on termination processes. However, we should also, as companies, try to explore other avenues if it involves claimants or employees who have served very long with the company. In this case, I just wanted to point it out that the court actually provided avenues or tried to suggest things like some misconducts could also justify a warning letter, a barring of annual increment, demotion, or even suspension. So alternatives to dismissal should always be considered, just to show that the company tried another avenue before resorting to dismissal. Then you have retrenchment-related dismissal cases, also a type of termination. The most important part of a retrenchment-related dismissal is to ensure that the retrenchment exercise is carried out in good faith. In order to make sure that there is no victimization, companies can always refer to the code of conduct, which helps the company to a certain extent when they prove their case in the industrial court. Next, we go to the final 2 cases, and these 2 cases have been recently decided. And why it is quite interesting is that before this, employers were allowed to rely on reasons that were not in the termination letter. However, after the case of maritime intelligence, it was clear that allowing employers to come to court and re-deliberating on the whole misconduct or whatever inquiry does not give a license to employers to introduce fresh matters. When we talk about fresh matters, things that were not included in the termination letter, not in the mind of the employer during the dismissal. Even when the question of law that was raised, the federal court in this case stated that the industrial court has no right to inquire into reasons that were only advanced at the stage of the industrial court. So that is where the federal court took a very strict stand and made to ensure that employers cannot rely on dismissal reasons which were not stated in the termination letter. This case also affirmed the principles that were applied in maritime intelligence. I'm reproducing the letter of termination that were contained in the judgment, wherein the termination letter, as you can see, it was a basic one to say that the current economic recession, a prolonged period of poor sales revenue, and also that the company's cash reserves are now at a critically low level. And then the company goes on to say that they can no longer sustain the claimant's employment and they have no other choice but to terminate the employment. The court held that There is also another information. During the trial, the employer tried to adduce evidence with regards to unsatisfactory performances, conflict of interest, and also sexual harassment. Again, the Court of Appeal here took the federal court stand for maritime to say that the employer cannot rely on other reasons. And further, in this case, it was also found that the retrenchment due to poor financial status of the company was not carried out properly, as the roles still exist. So sometimes companies tend to maybe try to put in any other external factors. The best thing to do is always to consider all the reasons that is attributing towards the dismissal of the employee. Think about it, state it properly in the termination letter to avoid being caught by the cases such as Maritime Intelligence and Malaysian Enterprise. So with that, I end the talk today. Pass it over to Elisa. Thank you very much.
Thank you, Mr. Navin and Ms. Caroline, for your wonderful insights on the termination of employment in Malaysia. So let's move on to the Q&A session for today. And it looks like there are a few questions from the audience. So the first question from the audience is that, does poor performance amount to misconduct such that it can be grounds of dismissal under Section 14(1)(a) of the Employment Act? And this question, may I pass it to Mr. Navin?
Thanks, Elisa. Okay, poor performance amounting to misconduct. Okay, so I think there's one thing that needs to be clear here. Misconduct is misconduct. When you talk about misconduct, you're talking about anything in relation to a breach of a policy of a workplace, or when you're talking about things like theft and everything, those are misconducts, things which definitely breach your contract of employment. But when you're talking about poor performance, your inability or your lackadaisical attitude in performing your tasks. So these kind of things, of course, poor performance is definitely different than misconduct. So there are different steps to take when you deal with misconduct. There are different steps you take when you deal with poor performance. Poor performance can be dealt with things as KPI, giving an opportunity to the employee to improve. Whereas misconduct, you're looking to get reasons from the employee as to why they are doing it. The two are different and should not be categorized as the same. Yeah, thank you.
Thank you, Mr. Navin. For the next question, can a substantial increase in workload also be considered as a form of constructive dismissal? Ms. Caroline, may I pass the question to you?
Yeah. So in the examples that I gave just now, I spoke about a decrease in your workload leading to a claim for constructive dismissal. It can be arguable that if the increased workload here is very clearly and substantially outside of your job scope, then an argument can be made out for constructive dismissal. However, you need to ensure that all the other elements of constructive dismissal are also complied with. In situations like this, it is sometimes hard to show the industrial court that this is the reason that you consider yourself to have been constructively dismissed. So you need to show that the company has acted in this manner, breaching your employment contract by giving you a substantial increase in your workload outside of your job scope. And then everything needs to, like how I mentioned just now, everything needs to be recorded, all your documents need to be in order, and that you also have made it clear to the company that you are now giving me this substantial increase in workload without any help, and I can not cope with it. And once you have put them on notice, you can also put it in that letter directly that if this doesn't improve or the situation doesn't change, you will be considering yourself as constructively dismissed.
Thank you, Ms. Caroline, for the comprehensive answer. So let's move on to the third question for today. If an employee is absent without leave from work for 2 consecutive days, can the employer immediately terminate them on the third day solely on this basis? If the employer reaches out to the employee to check it on why they have not turned up, and the employee responds on the evening of the second day but still does not turn up for the work on the third day, can the employer immediately terminate them, or does the timeline of 2 consecutive days start from the date of last response from the employee? May I pass the question to the speakers?
Yep, I can take this one out. So in a situation like this, yes, you can be immediately terminated if an employee has been absent for more than 2 consecutive days. However, this employee can only be terminated if they have no reasonable excuse for their absenteeism. In this circumstance, if the company doesn't accept the reasoning that is provided by the employee, then you can terminate the employee on the third day. If you have accepted their reasoning, however, then the time will start running from the next period of absenteeism.
Thank you, Ms. Caroline. For our fourth question to Mr. Naveen, do employers need to pay layoff benefits to fixed-term contract employees based on their years of employment?
Yeah, thanks, Elisa. One part of the question which actually is a little surprising is that based on their years of experience for fixed-term contract of employment, I think I need to make it clear here that if you are looking at based on years of fixed-term contract, then I think you have a fixed-term contract which is disguised. Because if it's a true fixed-term contract, you're looking at maybe one or two renewals. But if you're looking at years, I think termination benefits generally don't apply to fixed-term contracts. But however, if you look at a multiple renewal system with regards to the fixed-term contract, then you're in trouble, because then industrial court may take the opinion that your fixed-term contract is in fact not a fixed-term contract, and it is merely a disguise to avoid liabilities as a full-time or permanent employee. So termination benefits definitely apply to permanent employees, full-time employees. However, if it is a genuine fixed-term contract of employment, the termination benefits then don't apply. It is all based on the contract. Thank you.
Thank you, Mr. Naveen. Another question to you. If an employee is suspended with pay for alleged poor performance, what can the employer do after 2 weeks suspension period? Can they terminate the employee without notice?
Thank you, Elisa. So the question was, if an employee is suspended with pay for alleged poor performance, what can the employer do after the 2 week suspension period? So it is interesting because for alleged poor performance, usually the solution taken is not for suspension, but to allow the employee to improve himself. So when it's suspension, I believe that the mechanism is not quite correct. However, maybe there are other facts and things to play, so I wouldn't know. But definitely, I would say poor performance is not something for suspension to take place. So yeah, but if it is a misconduct and you are suspended and the employer follows the show cause procedure and provides you with a reasonable explanation, but at the same time you are suspended with pay, then of course the employer has the right to terminate, provided that all the satisfactory elements are satisfied. Thank you.
Thank you, Mr. Naveen. For the next question, as technology is being used by organization in DI hearings, if the employee requests from the company for a video recording of the DI, is the company obligated to provide the video recording of the session? Must this be stated in the company policy that we do not provide such recording as part of the DI hearing to protect the company? Ms. Caroline, could you address this question?
Yep. So with the current provisions and the current situation of things is that actually if you hold a domestic inquiry, upon request of the employee, you have to provide them with a copy of the notes of the domestic inquiry. The notes and the minutes taken should be taken in verbatim anyways, just to ensure accuracy and transparency and those kind of things. For now, the provision is that the minutes have to be shown on request, but it is best practice for everybody that is present at DI as well as the employee to sign off on every page of the domestic inquiry as a acknowledgement of the fact that those things were actually said by them and by the company's representatives as well. There is no strict requirement that the recording be given, but on a very practical basis, in the event that the DI is held and the minutes are taken in verbatim anyways, there is no harm to the company to provide that recording to the employee.
Thank you, Ms. Caroline. Moving on to our last question for today's talk. Is the law applicable on if a person is in probation period?
I'll take this question, Elisa. Okay. I think I better just make this clear, because with regards to the difference of a probationer and a confirmed staff, the only difference is when a probationer files for unfair dismissal, they only get back wages of up to 12 months. Permanent employee gets up to 24 months. Other than that, a probationer enjoys all the same rights as a full-time and confirmed staff. So there is no difference with regards to probationers and full-time employees. They enjoy the same rights and they should be enjoying the same rights. That will be all.
Thank you so much, Mr. Naveen, for your comprehensive answer. It seems that we have lots of other questions as well. But due to time constraint, we would have to end the Q&A session for now. So before we conclude, I have a few announcements to make. First, please join us again for a talk that will take place on the 18th of April, which is tomorrow at 3 p.m. entitled Applying for Planning Permission, Overcoming Approval Challenges in Project Development. Secondly, please fill in our feedback form and tell us what you thought about our talk. The link to the form will be posted in the chat. Next, you could also follow or like our social media accounts as we are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation up to 30 minutes over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us. We hope you have found today's sessions informative and useful. Thank you, everybody, and see you at our next talk.